Hello everyone, welcome to the NPTEL online certification course Medical Law. As you all know that we have gone through various modules, the first module, second module, third module. So today we will discuss on module 4th. Already the two lectures are over. Today we will discuss our third lecture of our module 4th, that is on the law regulation towards the clinical establishment. Myself, Dr. Chaitanya Mittal, medico legal consultant at Dr. B.C. Roy Multi Speciality Medical Research Center, IIT Kharagpur. So today we will discuss on module 4th, lecture 18, that is the legal liability of various clinical establishment or healthcare sector or the hospitals. So the important topics or the concepts covered will be in this lecture are the direct liability of the hospital, vicarious liability of hospitals or healthcare sector or even clinical establishment, liability of hospitals under specific laws. So the important keywords: the reasonable care and skill, independent contractors, adulterated or counterfeit pharmaceutical products, respondent superior. So the introduction about the various clinical establishment or the healthcare in the healthcare sector, how the hospitals are having the law guidelines or the law regulations. Indian hospitals have been subjected to legal accountability for their provision or lack thereof of medical services, either on an individual basis or through the principle of vicarious liability. वाइक्रस लाइबिलिटी एक आम भाषा में मीनिंग है राजा. राजा की हर ड्यूटी है. द पर्सन हु डूज द वर्क अंडर हिम और हर, वट एवर द वर्क ही हैज डन, गुड और बैड, द इट लायबल बीइंग द किंग. सो द वाइक्रस लाइबिलिटी. सो द हॉस्पिटल or the main employer, so that will be the vicarious liable. Legal action can be initiated against them for carelessness in many legal forums, including criminal court, civil courts or consumer forums. The liability of a hospital, that can be either direct liability or vicarious liability. Direct means directly the things have happened or any mishap happened, not under a reasonable skill and care, that hospital is directly responsible. But if the hospital staff has done such, so the employees under that particular employer or the head of the hospital, so the head of the hospital will be the vicarious liable. So direct liability of hospitals. In this context, the term direct liability refers to the hospital's failure to meet certain service standards, which in turn renders the facility dangerous and unfit for medical treatment. The following are some of the circumstances under which a hospital may be held directly liable: inadequate maintenance of the hospital, which led to the patient being injured or perhaps dying as a result; failure to provide a safe and sufficient environment as guaranteed, such as in the case where the patient is adversely affected by faulty equipment, incompetent staff, inadequate accommodation, etc. Under the Consumer Protection Act, deceptive or misleading signboards, advertisements and notices, as well as false claims of availability of specific facilities may be viewed as a defect in services or as unfair trade practices. Damages may be paid for such malpractices, and in some cases the law may even prohibit the business from continuing to operate. Charging for a facility that was not supplied or charging more than what is specified in the displayed list of charges or agreed upon is unethical. This includes charging for a facility that was not provided. There is a choice between a mandatory and optional testing for HIV and hepatitis B. When testing is legally done without the consent of the patient, it is referred to as required testing. For example, screening for blood donors, sperm donors and the organ donors all fall under the category of mandatory or required testing. In other circumstances, it is optional that the specific written approval of the patient is required in order to respect his or her requirement that the information be kept confidential. Incorrect preservation of treatment records and failure to pass over such data to the patient or his authorized attendant and legal authorities within 72 hours, both of which are violation of Medical Council of India Regulation 2002, which were created this regulation in 2002, now being as National Medical Commission. If such records are not given to the patient or the attendant, this may also be considered a violation of the Consumer Protection Act of 1986, now being as a Consumer Protection Act as a new amendment, due to the fact that it constitutes a defect in services. So, it is necessary under the RTI that particular records to be given to the patient or patient attendant with his permission, or under a few exceptions under a court of law enforcement agencies, medico legal cases, what are the rules under RTI that has to be followed by the hospital, preserving the medical records properly for particular so many years, like outpatient 3 years, inpatient 10 years, medico legal cases as long as the case continue, case dispose of. So, what do we mean by the vicarious liability of hospitals? Vicarious liability is when an employer is held responsible for the negligent action of their workers or the staff. This would apply to a hospital in its capacity as an employer. The employer is accountable not only for his own action and omissions, but also for those of his workers, so long as the action in question took place within the parameters of the employee's job responsibilities. The legal principles of the respondent superior, which translates to let the master answer, and the que facet per alium facet per se, which translates to he who acts through another does the act himself, form the foundation of this liability. So, the borrowed servant doctrine is a legal principle that provides an exception to the general principle of the vicarious liability. This principle states that an employer is not accountable for the action of an employee when that employee is performing their job duties while directly under the supervision of another employer. Then the another employer will be held liable, not that particular employer in which that employee is working. It is a borrowed servant doctrine. किसी और हॉस्पिटल का स्टाफ अगर किसी और हॉस्पिटल में आके कुछ काम करता है और कुछ गलत हो जाता है, तो उस हॉस्पिटल का जहाँ से वो स्टाफ बिलोंग करता है, उस हॉस्पिटल का एम्प्लॉयर विल बी वाइकरस लायबल, नॉट द पर्टिकुलर वन हॉस्पिटल वेयर द पर्टिकुलर procedure has been done by that employee. But if any fault is there from the hospital side, then definitely the hospital employer will be also liable. For instance, if a surgeon who works at one hospital travels to another hospital to perform an operation there, the first hospital may be held accountable for the actions of the travelling surgeon because the procedure was conducted at the second hospital. In today's world, the vast majority of the medical profession are not employed by the respective hospital, but rather work as an independent contractors. The doctor's relationship with the hospital will determine whether or not the doctor is considered an employee of the facility where he or she practices medicine. However, a hospital cannot avoid its legal responsibility by just claiming that it is unable to suo motu perform any type of surgery or amputation, and that it was only responsible for providing the necessary infrastructure, nursing services, support workers and technicians. So, coming to the famous judgment Srimati Rekha Gupta versus Bombay Hospital Trust and another, not only is the hospital accountable for the staff that it provides, but it is also responsible for the independent contractors like anesthetists, surgeons or even doctors, depending on the circumstances, who admit a patient or perform an operation on them. This was decided by the National Consumer Dispute Redressal Commission (NCDRC) in the matter of Srimati Rekha Gupta versus Bombay Hospital Trust in a year 2003, NCDRC CPJ 160. So, another judgment, Joseph Elias Papachan versus Dr. George Monjurali. In this case, in a year of 1994 by the Kerala High Court 782, it was decided that persons who run hospital are in law under the same duty as the humblest doctor. Whenever they accept a patient for treatment, they must use reasonable care and skill to ease him of his or her ailment. This decision was made based on the fact that persons who run hospital are in law under the same duty as the doctor or the treating physician. The administration of the hospital simply does not possess the necessary capabilities. They are responsible for it through the personnel that they hire, and if that staff is irresponsible in providing treatment, the employer is just as liable for the carelessness as anybody else who employs others to perform his responsibilities on his behalf. It has been decided that the state may be held directly liable for negligent acts that take place in government hospitals in the event that there is lack of appropriate facilities, equipment or staff. Additionally, the state may be held vicarious liable for negligent acts that are committed by its own medical professionals. In a few instances, the court has gone so far as to order the government doctor whose carelessness has been proven to pay the complainant compensation for the wrong they have suffered. So, coming to the liability of hospitals under specific laws, what are the liability of the hospital? What is towards the specific laws like Medical Termination of Pregnancy Act or the Drugs and Cosmetic Act or even the Organ Transplantation Act. So, the Consumer Protection Act. So, there are the various specific laws. So, what can be the liability of various clinical establishment in the healthcare sector? So, coming with the first and foremost the Clinical Establishment Act 2010. So, each and every healthcare establishment, whether that can be the private or even public, they should have a registered under Clinical Establishment Act. Whether if it is government, even autonomous body, there is an exemption, but definitely registration is needed with an exemption certificate. But that clinical establishment should be registered. For the all private, state, central, any, there each and every establishment related with the healthcare should be registered under Clinical Establishment Registration and Regulation Act 2010. A clinical establishment without registration is subject to a penalty of up to 50,000 rupees on the first violation. On the further repeat offender, the 2 lakh rupees on the second and 5 lakh on the subsequent violation. Anyone who knowingly works in an unregistered clinical establishment faces a fine of up to 25,000 rupees, but that should be a clinical establishment. The individual clinics or a one particular room, that can be run by the individual doctor, but if it is in hospital, even a small setup also need to be registered under Clinical Establishment Act. The authority shall convene an inquiry in the required way after giving an individual a reasonable opportunity to be heard to impose any monetary penalty. The authority shall consider the clinical establishment category, size, kind and local condition when imposing the monetary penalty. So, coming to the next act, the Drugs and Cosmetic Act 1940. The Drugs and Cosmetic Act of 1940 stipulates a range of penalties for various violations. The topic of concern pertains to the presence of adulterated or counterfeit pharmaceuticals. The potential legal consequences for the offence including a maximum prison sentence of 3 years and monetary penalty of up to 5,000 rupees. So, it is must or the liability of the hospital to follow it properly without facing any legal litigation. The possession or the distribution of adulterated or counterfeit pharmaceutical substances may result in a prison sentence ranging from 3 to 5 years as well as the monetary penalty of at least 5,000 rupees as compensation. The use of illicit substances in violation of regulations. The potential legal consequences for the offence include a maximum prison term of 3 years, a monetary penalty of up to 5,000 rupees or a combination of both a fine as well as a punishment. The possession and the distribution of adulterated drugs is punishable by a prison term ranging from 1 to 3 years as well as a fine of at least 5,000 rupees. The possession or a sale of counterfeit or contaminated cosmetics may result in a prison sentence of up to 3 years and a fine of at least 50,000 rupees or 3 times the confiscated cosmetics worth, whichever is being the greater. The court has the authority to impose a prison sentence for a duration of less than 1 year, provided there are sufficient and exceptional justification for doing so. So, in these the hospitals or the clinical establishment in healthcare will be held liable for the various violations under Drug and Cosmetic Act. So, for the new changes have come up in the Drugs and Cosmetic Act 1940, now being still as a bill, the Drug, Medical Devices and the Cosmetics Bill 2023, the Drugs Bill, seeks to replace the previously existing Drugs and Cosmetic Act 1940. Medical devices were considered a part of drugs under the Drugs and Cosmetic Act 1940 and both sorts of products were subject to the same set of restrictions. Nevertheless, given the enhanced complexity and technological advancements of medical devices, it is evident that they should be treated as a separate category. Consequently, the Drugs, Medical Devices and Cosmetics Bill 2023 established distinct regulation for these devices distinct from those governing medication, but still as a bill. It has not been passed in a Rajya Sabha to become as an act. So, still the Drugs and Cosmetic Act is valid, but soon if this bill has come up as an act, so then this will be applicable, the medical devices will be separate out. So, coming to the next act, the MTP Act, the famous 1971, which is also has an amendment we will discuss further. The act of terminating a pregnancy by an individual or by a doctor in a healthcare setup. So, how the hospital or the clinical establishment will be held liable. So, the act of terminating a pregnancy by an treating doctor or a professional who is not registered a medical practitioner is considered a criminal offence under the Indian Penal Code 1860. This offence is punishable by a term of rigorous imprisonment, which must be a minimum of 2 years and may be extended up to 7 years as specified in a IPC 1860. So, the liability of the hospital under this MTP Act, the individuals who terminate a pregnancy in a location other than the one specified in the Act will be subjected to punitive measures, including a term of rigorous imprisonment ranging from a minimum of 2 to maximum 7 years. Individual who possesses ownership of a location that has not been sanctioned in accordance with the Act shall be subjected to penalty of rigorous imprisonment or even a fine, or both. The duration of this imprisonment shall not be less than 2 years, but can extend up to the 7 years. So, what the new changes are there as MTP Act 1971 now being as in 2021. The primary objective of MTP is to enhance the women's accessibility to secure and lawful abortion services based on medicinal, eugenic, humanitarian and societal justification. Now, the amendment has done which has extended the upper gestational limit of doing the termination has been extended up to the 24 weeks for a specific groups of women from 20 weeks which was previous, such as the survivors of the rape, victims of the incest and other vulnerable women, including the differently abled women and the minors which are even unmarried. So, that gestational limit has been extended and also the termination can be done by the single doctor up to the 20 weeks. So, which was up to the 12 weeks in the previous. So, the various amendments has come up. A single provider opinion will be necessary for pregnancy up to 20 weeks, but 2 physician opinion will be required for terminating pregnancy between 20 to 24 weeks. After that, the medical board to be needed for case of fetal anomalies or any special circumstances in from the through court of law. The upper limit for gestation does not apply when there are significant fetal abnormalities diagnosed by the medical board. The identity and the personal information of a woman whose pregnancy has been terminated shall remain confidential unless disclosed to an individual authorized by the current legislation. It is very much necessary to hide the identity. If the identity is being revealed, then the hospital also will be held liable. The doctor or the treating physician who is revealing the identity is also held liable. So, the identity should not be revealed of the woman undergoing the termination of pregnancy, even to the police law enforcement agencies over the phone or any document. So, just have to mention XYZ whatever, unless being asked by the court of law. So, under another act, under Mental Health Care Act 2017, the individuals who operate a mental health establishment without proper registration are subject to penalties ranging from a minimum of 5,000 rupees to a maximum of 50,000 rupees for the first offence. But if there is a repeat violation for a second offence, the penalty can increase of a minimum 50,000 rupees can extend up to the 2 lakhs rupees. So, the healthcare establishment for a treatment of mental patients, the mental health establishment should have a proper registration. Otherwise, there is a violation, will be held liable for an imprisonment or a fine. Subsequent offences carry a penalty ranging from a minimum of 2 lakhs to max to 5 lakhs of rupees. Individuals who intentionally assume the role of a mental health professional within an unregistered mental health establishment as defined by this legislation shall be subject to penalty of up to 25,000 rupees. So, even the healthcare professional, the treating doctor should not also work in an unregistered mental health establishment, otherwise he will or she will be also held liable for a penalty. So, coming to the next act of a biomedical waste management, but now being as a rules of 2016. So, according to the biomedical waste management rules of 2016, the responsibility for enforcing the biomedical waste management rules of 2016 rests up with the occupant or the individual who possesses administrative authority over the healthcare institution. The individual in question will bear the responsibility for any potential damage inflicted upon the environment or the individuals as a result of mishandling the byproducts produced by the facility. In the event of any infringement, the individual in possession shall bear the responsibility for legal proceeding pursuant to section 15 of the Environment Act 1986, Environment or the Protection Act of 1986. Legal actions for the infringement of the provisions under section 15 of the Environment Protection Act 1986 encompasses the following measures. Individuals may be subject to imprisonment for a maximum period of 5 years, a fine of up to 1 lakh rupees or both. In the event of persistent violation, an extra fine of up to 5,000 rupees may be imposed for each day of infraction. If the violation persists for more than 1 year from the initial date of violation, the perpetrator may be subject to imprisonment for a duration of up to 7 years as determined by the respected courts. So, the next act, the Organ Transplantation Act, the Transplantation of Human Organs Act 1994, which is also being amendment to be done. Now, the tissues being added in a 2011, and then the rules have come up. So, the Transplantation of Human Organs Act 1994 was legislated by the Parliament in 1994 and become effective from the Feb 4th, 1995. The primary objective of the Act is to govern the extraction, preservation and transplantation of the human organs for medical treatment and to prohibit any commercial transactions involving human organs. So, any violation towards this Act, the hospital or the healthcare establishment will be held liable or will be under done an offence and will be under penalty. The Act includes a comprehensive provision regarding the authorization for the removal of human organs, the preservation of human organs, the regulation of hospitals that carry out the removal, storage or transplantation of the human organs, the responsibilities of the appropriate authority, the registration of hospitals, and the consequences for offences related to the aforementioned matters. So, the amendment happened in a 2011. So, the Tissues Act or the tissue part being added, or they have increased the relative or the like grandparents and grandchildren being added for giving the consent. The Transplantation of Human Organ Act 1984 underwent amendments in 2011, now being to be said as a THOTA, the Transplantation of Human Organs and Tissue Act, after being added by the tissue, but that does not include the blood. Blood comes under the Drug and Cosmetic Act. Blood is not a part of tissue. And then the amendment rules have come up in 2014. The act includes the several significant reforms aimed at promoting the organ donation. The modified act includes the establishment of a retrieval center to facilitate the retrieval of organs from deceased or donors and their registration. The definition of near relative has been enlarged to encompass grandparents and the grandchildren. Swap donation donor exchange is covered. The process of certifying brain death by the Brain Death Certification Board has been simplified, allowing for the inclusion of other experts in this certification. An obligatory investigation and notification choice to contribute in the event of the regrettable occurrence of brainstem death of an intensive care unit patient with the intention of organ donation. A transplant coordinator is required to oversee and manage all aspects pertaining to the extraction or transplantation of human organs. The National Human Organs and Tissue Removal and the Storage Network operates at multiple locations and includes a regional network. National database of donors and recipients to be created. So, all these needed to be there in a healthcare establishment where the organ donation and the transplantation need to be done. If any changes or any violation under this act being done, then the establishment will be held liable or has done an offence. The registration can go away or the even held for penalty or a punishment. So, we will discuss in further lectures in further modules of complete of organ transplantation. Today just we are for the liability part of the healthcare establishment where the organ donation or organ transplantation happened. A skilled technician has been authorized to perform the removal of the eye in order to facilitate eye donation. If skilled technician is not being hired by the establishment, then will be held liable. In order to safeguard the weak and impoverish, strict punishment have been established for the act of trading organs, including imprisonment of up to 10 years and a fine of up to rupees 1 lakh. The act has implemented strict measures for the minors as well as the foreign nationals and also a complete ban on organ donation for those with mental disabilities. Need to follow the proper guidelines, proper the consent part, proper the authority being made by the healthcare establishment under this act. So, the transplantation of human organs in 1994 also provided their services to the hospital and engaged in an unauthorized removal of human organs for transplantation either by conducting, assisting or associating with such activities shall be subjected to punishment for a maximum period of 5 years and a fine which is not exceeding the 10,000 rupees. So, this is also same being there in the current 2011 as well as the amendment rules 2014. So, the individuals should perform their services in properly registered hospital and should follow the rules and guidelines which are being mentioned in the act. When medical practitioner commits offence in the event that an individual is a registered medical practitioner, the appropriate authority is required to inform the respective state medical council. The council will then take appropriate measures which may include removing the individual's name from the council's register. For the first offence, the removal will be for a duration of 2 years, whereas for subsequent offences, the removal will be a permanent or penal erasure from a register. So, when the hospital commits offence in the event that a company commits an offence that is subjected to punishment under this act, all individuals who were in a position of authority and responsibility for overseeing and managing the company's business operations at the time of offence was committed in addition to the company itself shall be considered culpable for the offence. Subsequently, they shall be subject to legal proceedings and appropriate penalties. So, whenever the hospital or a healthcare establishment commits the offence not following the act which is being mentioned in the Human Organ Transplantation and Tissue Act 2011 and further the rules of 2014, then the hospital will be held liable and has to follow the whatever the penalty or the punishment given by the court. So, coming to the conclusion of this lecture is the integrate legal dynamics among hospitals, physicians and paramedical personnel, which give rise to challenges that pose difficulties for courts in reaching resolutions. The hospital bears both a vicarious and a direct and intrinsic duty of care, which can be considered as a corporate obligation towards its patient. It is not only the doctor will be held liable, it is the hospital or the employer of that healthcare establishment under which the operation or the treatment has done by the treating physician will also be held liable or vicariously liable of any mishap or anything negligently that happened. There exists a need not only to create initial standards of care, but also to engage in ongoing monitoring of these standards and implement proactive method to ensure their regular updates. So, it is the duty of the employer of any healthcare establishment that the hospital or the establishment should be properly registered. All the licenses are up to date, they are not even a single is expired. All the doctors, all the staff who are working under that hospital or establishment should have the registered medical practitioner, they are registered under State Medical Council or the National Medical Commission, or they are following all the rules and the guidelines of the various acts and the Supreme Court guidelines for doing the procedure and the treatment. They are not doing any violation or any mishap or any misfortune or any adultery part happening in the hospital from the doctor side. So, it is all the duties of the employer or the hospital administration or the healthcare establishment to take care the things happening in the hospital with the rules and regulation. Otherwise, the hospital or the establishment will be held liable for a particular punishment and the imprisonment by the court of law. So, these are the references for the further readings. All audience students can go through their various PubMed articles and the sites for the further understanding over the legal liabilities of the healthcare establishment in a healthcare sector. Thank you very much.